Now we're going to get into the stuff that I think is, frankly, a little bit more interesting than what we've been talking about. A couple of the defenses that you all enjoy. First one that comes up a lot is drugs. As you may or may not be aware, there's a couple of drug provisions in the statute. They are that if the employee, if there was use of drugs in conjunction with the accident or the injury, then the employer enjoys a 50% reduction in the benefits that are owed to the employee, and that's medical care, TTD, PPD. Well, what is in conjunction with? In conjunction with is defined as at or near time and place. So what is at or near time and place? Don't know. There is one case that talks about this. It doesn't come right out and say exactly what you're hoping. You know, you read these things, 8 pages, and like, all right, now they're going to say it, and then they just say, and we affirm, without getting to the meat of it. But those Nolan v. DeGrasse admixtures, and I'm not absolutely certain that's the spelling. Again, this was one of those I was just trying to do from memory. That there was a use of drugs. The employee tested positive for methamphetamine and marijuana. And the evidence proved to the trier of fact that the methamphetamine was consumed within 3 days prior to the accident occurring, and they upheld the 50% reduction. Now, the court did not say, hear ye, as long as they've had drugs within 3 days prior to the accident, that is conjunction with, okay? They were really talking about some other issues in the case, but the court did not say, well, it was 3 days prior, so that's not in conjunction with. So the inference is that at least they tacitly blessed use of drugs 3 days prior to the injury as in conjunction with. And that seems to be working. I've got a case right now that is a very significant case, and we've got a toxicologist who has provided a report saying that the drugs were consumed 3 days prior to the accident, and it's got the claimant's attorney worried about it. So we may settle it because of that. That last paragraph should be on the next slide, so ignore that for a second. We'll come to the next slide, and then we'll come back to that. You know, when you've been drinking 3 cups of Starbucks coffee, you don't know what you're going to do doing this thing. So there is another provision that I didn't feel was necessary to put on here for whatever reason, that if the use of the drugs is the proximate cause of the injury, then it's 100% forfeiture of benefits. You know, why would I tell a bunch of employers that little gem, right? I can't believe I didn't put that. Oh, there it is. Okay, it is that last paragraph. So if the use of the drugs is the proximate cause, okay, then it's 100% benefit or 100% benefit reduction. What's the difference? All right, in conjunction with, if somebody goes and takes a hit of whatever during lunch break, that afternoon they are doing whatever and the crane falls and injures the person, the fact that the person had consumed some illicit drug in no way contributed to or caused that accident to occur, but you still get the 50% reduction, okay, just by virtue of in conjunction with. However, if the crane operator takes a hit of whatever is high, as a result of them being high, they make a poor decision that results in injury, now you've got this proximate cause, and you get the 100% benefit difference. There's a provision in the statutes that somebody who tests positive above the legal limit for alcohol, then it is presumed that it is proximate cause. Presumed doesn't mean that's the end of the analysis. That just means that now the judge starts by assuming that it was proximate cause, and the claimant has to prove that it wasn't. Okay, so even if they are blowing a .20, standing there minding their own business, and the crane falls on them, that's not going to be proximate cause. Okay, I think in that situation, the claimant's attorney could successfully rebut this presumption that it was proximate cause, and it would just be a 50% reduction. All right. The the way these things come into play oftentimes is you've paid medical, because you can't pay the doctors half and say, well, there was drugs. So you pay the doctor the amount, and then once the drugs issue starts getting explored, all right, employee, normally you would get another $15,000 in PPD, but since we paid $30,000 in medical and we are entitled to a $15,000 reduction, we're not going to give you the PPD because we get a credit for 15, which is what we would owe. We're square. Have a great day. So that's generally how those things play out. They are rarely tried, the drug penalty. It is more often than not, these cases settle, okay, when this drug, because these are the situations where nobody really wants to hear what the judge has to say because there's a chance the judge will disagree with you, and that could be a significant difference. So oftentimes these cases settle. There's one caveat, and that's marijuana. For those who don't know, marijuana metabolizes in the system differently. I'm going to sound like I know what I'm talking about here. I don't really, but I've read enough stuff that I can pull it off. So if anybody has something to add, feel free to jump in there. But the way marijuana is metabolized by the system, what ends up in a person's urine is a metabolite that is not THC. It's this carboxy THC or something similar to that, that is non-psychoactive, all right? But it's a marker of THC consumption because it's what the body produces once it has the THC. However, it can be in and detectable in a person's urine for days, weeks, and months after the consumption. And how long it stays or is detectable is dependent on several factors. I think the primary factor is what are the habits of the person. Okay, a real professional hippie, all right, they're going to have THC, COOH in their urine for a long time. Okay, a one-hit wonder, it's not going to last very long. All right, so what do you do with these things, and how do you? First of all, you bluff a lot. Okay, because claimants' attorneys, we have repeat clients, so we have to really know what we're talking about oftentimes if we want to keep our clients. Claimants' attorneys, not always the case, so you have a lot of folks that just like, yeah, sure, I'll do a comp case. I've seen that on TV. It doesn't look that hard. And so I start saying 50% reduction or 100%. I get some THC carboxy, so look out. And that may be enough, all right? But if it's truly a claimant's attorney that knows what he or she is doing, adjusters can get a lot more excited about a positive marijuana test result than they probably should. And it's because that a positive of this, I mean, I've seen 300 plus nanograms per milliliter of this metabolite in a positive test result, and that isn't necessarily indicative in and of itself that the person had recent consumption. Now, if I take the person's deposition, have you ever consumed drugs? Well, they know they're going to say yes, right? Because we've got the test positive results. But they're probably going to say, one time, twice maybe. And I didn't even inhale, right? Well, that's good, okay? If they say that, now I can go to the toxicologist and say, look, I want you to assume these facts. This is a person who does not regularly consume marijuana by their own admission. So now when you've got these 342 nanograms per milliliter of this carboxy tetrahydrochloride, so on and so forth, in their bloodstream, what does that tell you? And they're going to say, well, if it's somebody who doesn't consume this very much, that's a very high amount in the urine, therefore it is probably somebody who has consumed recently. So oftentimes the attorney for the claimant and the claimant don't realize that while they think they're helping themselves out, they're actually hurting themselves in this situation. So the best, the other drugs, the methamphetamines, the opiates, the cocaine, all the other stuff, not the case. If it's detectable in a certain amount, I think the toxicologist can fairly and reasonably give you some information about when it was last consumed. And if it's in that 3-day window, you've got at least 50%, and now you're starting to see if you can make a case for proximate cause. If you just have a positive, and of course most often I see positive marijuana, and it's usually tested through the urine. It's not as exciting as it sounds. It's maybe some good bluffing material, and maybe get somewhere with it, but you can't bank on it. All right. If they can do a blood test, and I've had cases where it was I had a car accident. State Patrol took blood, and it tested and found the substance in his blood. That's a whole lot better. That it gives a lot better idea of when there was consumption, because it doesn't stay in the blood near as long as it does in the urine. So drugs are great for negotiation and limiting liability on these things. When can you test an employee? There's a couple of situations. The two times when you can test an employee. One is if you have a drug-free workplace policy, provides for post-injury testing. And the other is if the employer has a substantial belief or substantial reason to believe, some fuzzy language like that, has a belief that drugs were involved in the accident. All right? There is no reason that an employer should ever use this, I have reason to believe that there were drugs, so I want to test, okay? Right now, you can go back to your office, and if you don't already have it, start putting in the works to get a drug-free workplace policy that provides that employees will submit to a drug test if they have an on-the-job injury. I'd word it a little bit more eloquently than that, but certainly something along those lines. Because if the employee refuses to take the drug test when the employer had a right to insist on it, it doesn't matter whether it would have been positive or negative. It's 100% forfeiture. All right. So the problem is if you're invoking the second right to test the employee, there's still room for a judge to get in there and make a decision. Okay. Well, did they really have? Was their belief substantial, or was it just a vague belief? In that the drugs were in play. All right, you have a chance that the judge is going to rule against you. If it's in your policy, and they say no, I'm not taking a drug test. All right, that's fine. That's it. No comp benefits. Okay. What is refusal? Oftentimes, though, the employee doesn't say no. They say, sure, I'll be right down there to take that test. You wait, they don't show. My car broke down. I'll be back tomorrow morning, first thing. You wait, you get it set up at the clinic or wherever, and had to get the kids were home sick, and you start getting these reasons and reasons and reasons. Now you have an issue that can be litigated. Was there a refusal? Okay. I'm not telling you that there's any hard and fast rule on when you can say, all right, sometimes things do come up, okay? Sometimes meteors do fall out of the sky and block the one road out of your neighborhood, all right? But, at least you've got some, you can make the case. And again, what I'm looking for as the attorney is as many arrows as I can stick in the quiver to explain to this claimant's attorney who does a lot of probate work and just picked up their uncle's comp claim why they're going to lose, and so that I can hopefully get the thing settled, and you pay a little bit, but a whole lot less than what you might have to pay if you get to a hearing. So this is a no-brainer. If you leave here and don't go check your policy, well, that's just silliness. Okay, check it. If you don't have anything that suggests that you have an absolute right to take a drug test after an injury, send it to your whoever does your business stuff, your general counsel or to an attorney, and get that put in there. Okay, you'll really be happy that you did, I think. Any questions about that? And let me back up that I didn't write it out in here. You have to actually have, by the way, a drug-free policy, even to invoke the 50% and 100%. Okay, what I was just talking about is in order to insist that there is testing, you got to have that provision in the drug-free work policy. But to even get to to enjoy these benefits, you have to have, by the way, a drug-free work policy as well. Okay, if you don't have a policy and they test positive for drugs, doesn't matter. All right, they're still going to get every bit of their benefits. Questions about drugs? I had an adjuster tell me last night I had to call on a case, and the claimant is unhappy with the doctor that he is being sent to. He got a prescription for Oxy, one of them, and when he got home, he lost the prescription and wanted a second prescription. And, I'm sure he had that thing laminated, when he was leaving the office. Lost it in my butt, So I've got you back there. And refused to get they wouldn't send him back for another prescription, or the doctor wouldn't give him another prescription. So he called the adjuster and said, well, fine, I'm going to go find the nearest N-word and get some heroin to solve my problems. So, of course, made a note of that, and forward that on. That's now in the file, and I'm sure that will come back at some point and we'll readdress this issue of how he's treating his pain. But I just thought that was interesting. We're talking about drugs. Young lady in the green first, and then I'll get you in the back row. Yes, ma'am.
If you have an employee who is taking a cocktail of legally prescribed drugs,
Yes.
and they're performing a job which those drugs may inhibit
Mm-hmm.
performance on that, do you have to tell the employer?
Well, okay. You weren't asking the question I thought you were going to ask, and so I started answering a different question. Let me repeat your question for the sake of our audience that isn't here. If the employee is taking a cocktail of drugs which they have been prescribed, and they are taking the amount that has been prescribed and all those things, do they have an obligation to tell the employer about those drugs, certainly if the use of those drugs may be a problem on the job? Fair? For instance, driving, yes. Well, let me answer what I think is the easy question, the question that I thought you were going to answer. Don't you love that? Yeah. One, that would not be drug penalty under any circumstances because it does require illegal or unprescribed drugs. Okay. Now, do they have an obligation to tell you, and what happens if they don't? That's a hard question to answer, okay, because what starts coming to mind is ADA, protected health rights. However, your genuine right to try and limit your liability and to protect the general populace from, drug cocktail drinking employees. So it's, I don't really know how, I don't know that there's a good answer to that question. I certainly don't see that you can put into your drug-free work policy that the employees have an obligation to inform the employer of all prescribed drugs they're taking. I mean, that would get you in a sling, I think, pretty fast under ADA and ACLU and every other A out there, okay? So you probably can't do that. But at the same time, if you have reason to believe that they're taking medication, then I think, certainly they have, the ADA only applies to the extent that they can't perform the essential functions of the job. If the essential function of the job is driving, then you can't make a reasonable accommodation. Then I think, now we are in an area where, wait a second, I've got to get you off the road. But then, how do you ask the question? I don't know. Hopefully you've asked in your application or during the interview process, do you have any condition that would prevent you from performing the essential functions of this job, right? That's what everybody asks, and they've been told that's what they have to ask, and they don't know why, but it's because of the ADA, and it's this kind of situation. So taking drugs and driving are, I don't think those are consistent activities, if the drugs are the type that prevent you from driving. And so they have not been forthcoming on their application, or the circumstances changed and they didn't let you know. I give you 90 seconds of, I didn't answer your question though, I know. So I don't really know. Certainly in a liability case, when you get sued because your employee mows down somebody and you get sued under what's called respondeat superior for the negligent acts of your employee, to the extent you can try and deflect some of that I didn't have I didn't have knowledge, but that doesn't really matter. If they're working in the course and scope of their employment, then you're on the hook without whether you had knowledge or not. But is it outside the course and scope of employment for them to be driving with all these drugs in their system when you've asked them the question? Is that beyond the license or permission that you gave them to drive on your behalf with drugs in the system? Boy, that's It's a great argument in a law school classroom setting, but I don't know how well it would fly in the court. So it's a very tough situation. I mean, we all know these ADA regulations oftentimes come up and probably are a thorn in our side, not because we want to try and discriminate against the disabled, just it's tough to comply with, and I get that. I see you back there, but I've got someone in the back row over here. I forget who it was, and then I'll come to you. Yes, ma'am. Perfect. Moving on. No. No, go ahead.
This scenario happens where I work quite often. I'll give you one example. An individual fell off a boulder.
Okay.
He hurt his shoulder a little bit, but he did not want to turn in a work comp claim. He did not want to go to the work comp. And he just went home.
Mm-hmm.
And he did not turn in.
Mm-hmm.
Well, then 3 days to 4 days later, then now he thinks it might be work comp because it's not getting better. And then he drug tests them 3 or 4 days later.
Right. You don't, the employee doesn't have a right to decide whether or not there has been a comp claim or comp injury or not, right? The facts determine that. Either he was hurt on the job or he wasn't. Now, certainly he has the right to pursue it or not pursue it. But I would say in that circumstance, if they are injured on the job like that, first thing you're going to do is you're going to file a report. You're going to file a report of injury. Don't ever get suckered into, well, I think it's okay. Don't worry about it. You don't file the report of injury because you don't have a file the report of injury within 30 days unless the employee says it's okay. Okay, unless the employee says it's okay, it's not in the statute. You've got a duty to file the report of injury, and it's a misdemeanor to fail to do it. Nobody's ever been charged with that crime, but it is a crime. So file the report of injury, and also tell them, head on down to the drug test. Well, I don't want to file a workers' compensation claim. I don't care. You've got to do it. Okay. And because obviously they have the right to, they might very well change their mind, and they've got 2 years to change their mind. You've had notice of it, so they can change their mind 730 days later. 729. Yep. Yes. Yep. Okay. Because there was an injury. You have in your policy that after an on-the-job injury, the employee must submit to a drug test. They refused. It doesn't say after they filed the claim, or they must submit a drug test after they've formed the decision to file a claim. Okay. It is after there's an injury. Make them do it. And if they say no, say okay. Document in the file that they, that you gave them a memo or whatever. Show up to Acme drug testing, and they say, no, I'm not going to do it. You say, that's fine. Just sign here that you're refusing. Okay? And since you're not going to do a comp claim, that's fine. And then 3 days later, and they say, no, I think I am going to do a comp claim. Okay. File it, you've got the report of injury. You've reported you send that to the insurance company, and that'll be the defense material. Now, you can't stop them. One of the unfortunate problems with comp is there is no motion practice. You can't file a motion to dismiss in workers' compensation. And you can't get a summary judgment. And you can't go, Judge, there's no way they're going to win on this. Make it go away. All right? They can file their claim. They can fool around. They can get their treatment. Your insurance company is carrying the claim all this time. You're telling them how you're not going to get paid, but it's not until you have that hearing and the judge takes as evidence that refusal and then awards zero benefits that it's finally settled. So that's unfortunate byproduct and might come up in a situation like that. But absolutely, make them test. Yes, sir. In the back. Yes. Nope. Standing up in the back right there. wording it right, narrowly tailored, and making sure it fits within the system. It can be done, but it's difficult. I see you here, but I saw a hand over there, I think, earlier. Or am I seeing things? It's that marijuana 3 days ago. Yes?
Okay, so drug testing we do after every vehicle accident that they have.
Okay.
But we don't necessarily make it a practice whenever they twist their ankle or
Okay.
whatever. So the question is, if someone is waiting for a month, 6 weeks, 2 months to report a shoulder injury, they got a bruise or whatever that isn't going away, at that point, what is the point in doing a drug test?
I agree with you, and that's a problem. They if they knew they had the accident, which of course they did, they don't tell you about it, but they are presumably aware of the drug-free work policy that requires them to be tested immediately after, or as soon there as possible after an accident, and they don't notify you. Does that constitute a refusal to take the test? All right. It's a good question. I think strong arguments could be made that it is a refusal. It operates as a refusal. Okay, it's a constructive refusal. Those kind of things that we like to throw around. And I would certainly during negotiation, pound my chest about how clearly it's a refusal, and I'm going to win. Is that to say that a judge would agree with me? Some judges would, some may not. It can be. I think it could be a problem, and it's certainly open to debate. I'm not familiar with a case. I don't think there is a case out there where that situation has come up. As I said, for whatever reason, drug issues don't get tested in the courts as often as I would expect. It's not my money, but if it were, I would assert the drug defense more often and test more often. Now you've got to make a decision. And so there's a cost. How often are we going to test with every boo-boo? That may be a bad idea, but whatever you decide, I would test more often because there's a lot of positives out there. Yes, ma'am. Mm-hmm.
A situation like that lady, wouldn't she be able to do a random drug test if you were suspicious that someone was under the...
Are you talking about with the driving?
Yes.
Yeah, I mean, that's if you've got, however, is it truly a random test if you've got suspicion? No, it's not. Based on the very facts that you gave me, I'm telling you as a matter of fact. And now, it can certainly make it look, and what you're talking about now is how do I make it look random, which is very different than it actually being random, okay? So, that obviously it's not a random drug test if you do that. Now, will you get away with one? Maybe, depending on how you do it, I guess. I'm not suggesting you ever try and get away with anything. But as a practical matter, I suppose that effectively could end up being a way. I don't think it's a very good way. I think what we were talking about here is there's, if you can put the right verbiage in, the problem is you're still relying on the employee to fess up, and unemployment, when it's higher, there's less likely that they're going to do anything that might cause them to, not keep their job. So I can understand that there's probably a lot of employees that aren't fessing up to those things. It's just a problem, and I'm not sure there's an easy solution. If there was an easy solution, I wouldn't have a job. So, all right. See, I knew everybody loves the drugs. That's everybody's favorite. And this next one. There'll be a lot of what-ifs here. Okay, safety rules. Safety rules are a lot like the drugs, but they're also different in many respects, and it's important to understand the difference. If an employee is injured and injured as a result of not following a safety rule, then the employer enjoys a 25 to 50% reduction in benefits. First of all, every adjuster always assumes it's 50%. And so they tell me, well, we're going to get a 50% credit. And I say, well, it could be 25, could be 37.5, could be 21%. The judge can put it anywhere they want. No, we're going to get 50. All right, that's fine. Just keep in mind, it's 25 to 50. It's completely up to the judge's discretion on where they do that. I can just tell you, generally speaking, and I think probably most judges adhere to this, when I had to evaluate them, it came down to factors like how much was the employer trying to enforce the safety rule? How related was the injury to the safety rule? I mean, there has to be, at a minimum, the employer has to have taken reasonable steps to ensure that the employee follows the safety rule, and the failure to adhere to the safety rule has to be in part the reason for the accident as a minimum threshold. But is it just that? Is it the employer took barely enough steps to qualify and to meet this threshold decision that they took reasonable steps, or were they just pounding it in every 3 months? You will wear your safety belt when you are operating a motor vehicle for us, and we have placards on the dashboard, and we have monthly meetings, and if you're ever spotted doing it, you're reprimanded, and supervisors do it all the time. Okay, because these are things that come up when the employer finds out that somebody is not following a safety rule and goes, "Come on, Joe, I told you, wear your safety belt." "Yeah, I know. Okay, I will." 2 weeks later, "Joe, I told you, you really need to wear your safety belt." "Yeah, I know. I don't like it. I'm not used to it." "All right, well." You keep doing that, that's not reasonable steps to ensure that the employees are following the safety rule. Okay, that's the kind of stuff that when the employee then gets into a car accident and is horribly disabled because of it, and the employer is saying, "Well, we had a safety rule. You were supposed to wear your seatbelt. You didn't." He's going to say, "Well, yeah, but you didn't enforce it." And the employer's going to say, "Well, I kept telling you." And the employer's going to say, "Yeah, but so what? You just told me and didn't make me." Sounds very childish, doesn't it? And backyard stuff or schoolyard stuff, but that's kind of how those things shake out. And that's going to hurt you. If supervisors are not wearing their safety belt, all right, and then the employee gets hurt, and the lower level employee gets hurt not wearing their safety belt, all they got to do is say, "Well, Mr. Sammy supervisor never wears his or her safety belt." That's it. You're going to get it thrown out. You're not going to get the safety violation. So you got to have reasonable steps. And I would say that making sure everybody does it, making sure that you have periodic safety meetings, reprimanding, either in a verbal, but even better, a written reprimand and personnel files, because that's the stuff that you can later show to a judge with redacted information as to who got the reprimand. But look, these are all these reprimands we're putting in people's files for not doing this. We really are serious about safety belts. And the more you're serious about it, and the more you have safety meetings, the more you move over here. Okay, the less you do that, the more you are over here, I think. The statutes don't tell the judge what they're supposed to use to make that decision, but I'm just telling you that's kind of how it's done. Note, this employer must take reasonable steps to ensure that the employees follow the safety rule. That is not in the drug penalty. Okay. And that's come up. I've heard claimants' attorneys say, "Well, yeah, but they didn't really have safety. They didn't tell us they couldn't be high, and they didn't. Supervisors were high now and then." Well, none of that matters. Okay. In the drug penalty, if there is a drug policy and they test positive, it's either 50% or 20% or 100%. But this one, these are ever so difficult to win on because just the claimant can testify, "Yeah, they didn't really make us do it." Well, now there's an issue, okay? And if the judge tends to believe the employee, you don't get any safety. It's not a matter of, well, it's 25%. It's a you haven't met that threshold. So safety rules are good. They are good to have. They are great for bargaining chips and chest pounding in the negotiating these things. Just don't assume that just because you have it that it's going to be a winner every time. They are more difficult than the drug penalty, in my opinion, to prevail on because of this additional thing right here, this issue that gets injected on the employer's steps that they are taking to enforce the rule. Safety violation, questions about that? A couple other just last-second defenses. We've talked about them a couple times here as notice. The employee must give written notice to the employer within 30 days unless the employee can show that the employer is not prejudiced for failure to give written notice. And almost always, according to the judges, the employer is not prejudiced for failure to give written notice, so verbal notice always works. All right. It's got to be within 30 days. For the occupational disease cases, it's 30 days from when the doctor tells the employee that they've got carpal tunnel or whatever because of their work. It's not 30 days from when they first know about it or they first start experiencing pain. Statute of limitations, it's 2 years in Missouri for workers' compensation claims. 2 years from the date of the injury or 2 years from the last time benefits are provided to the employee. So every time that employee goes back to the doctor or gets a TTD check, there's a new 2-year statute of limitations. All right. It's kind of frustrating because that can make these cases go a long time. There is a claimant's attorney down in southeast Missouri that never files a claim. He prefers it to be a non-claim filed because he simply doesn't do anything on the files. He doesn't send his employees out to doctors to get reports. He doesn't make demands. He just sits and waits and figures after about 2 to 3 years the insurance company will make an offer just to get it off their books. And it's working for him. And he can do that for a long time because he can wait every time goes back to the doctor. It's another 2 years. It's a very frustrating situation, but there's virtually nothing that we can do to make him file the claim. And then if we get him to file a claim, then we can drag him in and say, all right, Judge, nothing's happening. When are you going to dismiss us for failure to prosecute? Even in those situations, it's very difficult to get a claim filed. If there was one thing that I would suggest to legislators about making one change that doesn't seem like it'd be that big of a deal, but I think it would cost or save employers big time over the long haul, is adding this motion practice to the comp system. And I know that sounds like, sure, Matt, it's another opportunity for you to build because now you can do a motion to dismiss, you can do a motion for summary judgment or whatever. But in fact, there are a lot of cases out there that I just simply can't get rid of them. They've got to sit and they've got to wait because the employee is not doing something. Or, it can be 4 years. I've got a case that is 4 years after the injury. The employee has finally filed a claim, and I can't make it go away. We've got to send him out to a doctor in case we lose on the statute of limitations claim and get an opinion. We've got to, I periodically send updates to the insurance company. I field requests from the claimant's attorney about statements that his employee has made. I have to take a deposition, all those things. I'd like to, on the front end, say, Judge, I'd like your ruling on whether or not this even is a compensable case because of the statute of limitations. It would get rid of it real quick. If you don't file a report of injury in that 30 days, as we talked about, then it's 3 years, so it's even longer. So always err on the side of filing the report of injury. It's not going to create a case where there's not one. Yes, the employee will get some notices, and that may make them think, oh, maybe I have a comp claim. But I don't think that the possibility of that happening is not near as bad as not filing a report of injury and then having a 3-year statute of limitations. Nothing terribly enlightening there, I know. Any questions about that? Oh, a brand new case just came out. Not that, December. TH versus Sonic. And they're talking about Sonic Drive-In, the restaurants. If the employer does not respond to the claim for compensation within 30 days by filing an answer, all factual allegations on the claim for compensation are deemed admitted. All right. Now, while that sounds shocking, it's really not that big of a deal, or at least didn't used to be that big of a deal, because things like the employee is devastatingly injured, that's not a fact. Employee is entitled to TTD and disability benefits, that's not a fact. Those are all legal conclusions. Those are not things that one can admit, so there really wasn't a big deal. The only thing that traditionally what was considered the type of thing that could be admitted was whether the accident happened, okay? Because oftentimes, they come back on a Monday and their back hurts, and it was the same weekend that they might have been putting up their Christmas lights. Did they get hurt at work, or did they get hurt putting up their Christmas lights? But if they have said that I was at work and this happened and I felt the immediate onset of pain, those are all factual statements, and those are deemed admitted if you don't file a timely answer. So that was really used to be the only drawback of not filing a timely answer. Well, what happened in TH Sonic is TH is obviously a minor, okay, because we're using initials. That's what the court does when it's a minor. And TH worked for Sonic. So I'm going to guess that TH was probably not making a whole lot of money per week. Let's say $8 an hour, working 40 hours a week, $320. times 2/3, $240 is the comp rate. It's a fair assumption. In the claim for compensation, TH's attorney, in the box that says average weekly wages, the claimant's attorney put max rate. Filed that claim. Claim was not answered within 30 days. The Court of Appeals said wage rate is a factual allegation, which I disagree with. And since they alleged max rate, it's been admitted. So instead of $240 per week as a comp rate, $425.19 is the max rate for when this injury probably occurred. So it almost doubled the comp rate. So a 15% of the knee just got twice as expensive, or whatever, any disability. TTD got more expensive. Max rate for TTD is $800 and change, $827.19, I think, currently. Well, instead of $240 for time off while they're getting the medical, they're getting $800 and change for TTD. That's 3 times. So this is, I think, kind of earth-shattering. I think it's wrong. And the reason I think it's wrong is for a couple reasons. One of the longest sections in the chapter is the section that deals with how we calculate wage rate. So clearly it's a legal analysis that goes into calculating wage rate. Also, there is no maximum wage rate. I suppose a Sonic employee could get $1,000 a week if it was a very profitable Sonic, right? The only thing that there's a max is comp rate. So if your wages, 2/3 of your wages is above a certain max, then the comp rate is set at a max. The claim form doesn't ask for comp rate, it asks for wage rate. So what the factual allegation that this claimant claimed was that their wages was the max rate, which is it's illogical. It's a nullity. It doesn't make any sense. Yet the court said, well, we're going to treat that as he meant to say comp rate, and we're going to set it at the comp rate. And I think it's unfair or disingenuous to when you're going to hold the employer to this technicality of answering within 30 days, but not hold the employee to the same technicality of answer the question that's asked, not some other question, although lawyers do that now and then, as I did earlier. It seems that it's unfair at a minimum. So I don't know why. I don't know how those arguments went. It seems like a no-brainer winner when you start looking at that there is no maximum wage rate. So I'm not sure how the arguments went or the pleadings, the briefings went, and I don't know who the attorney was that was representing Sonic. But at least right now, there's a court case that says, and I guarantee you every claim for compensation that we will see from now on will allege max rate for wages. I would. It'd be silly not to. So in the hopes that a claim doesn't get filed or an answer doesn't get filed for 31 days. So the takeaway, make sure everybody is passing on these things as soon as possible. Insurance adjusters, particularly, I know that's not, you all need to, sometimes we get on the 27th day, hey, I've got this claim for compensation, need it answered. Turn it around in time, but, that has the potential for being answered late, and there's some pretty drastic problems with this wage thing if it's not answered within the appropriate amount of time. Post-injury misconduct. You, as the employer, may fire an employee for post-injury misconduct if they commit misconduct and you fire them after their injury. It suspends, or they are no longer entitled to any TTD, comp wages, as of the date of termination. I've got positive drug screen here. Well, let me back up. Misconduct is not defined in this section or anywhere in Chapter 287, which is the comp law, as to what is misconduct. So we don't know what misconduct is. The next chapter over is 288, which is the unemployment chapter. They do define misconduct, which we will get to in the unemployment section, and it's a pretty high standard. Evil motive, willful, wanton, some really crazy language. But if that's I would suspect that it wouldn't be inconceivable that the comp judges would use that definition of misconduct when they're applying this, which makes for a pretty high standard, okay? The employee hits their thumb with a hammer and drops an F-bomb, that's probably not misconduct, okay? The employee gets injured and refuses to show up to work even though they've been released, or shows up drunk or does some other things like that. That may very well be misconduct. I told one of my clients that when the employee was at the doctor's office, got mad at the doctor, started smashing lights, flipping chairs, and got kicked out by the cops of the doctor's office, I suggested that was probably misconduct, and I think I'm right. Positive drug screen. That's another one that's come up in one of my cases. The employer fired the employee for having a positive drug screen. The drug screen was taken immediately after the injury, which suggests that the drugs were consumed prior to the injury, which is what I'm hoping, because then I get the drug penalty. But is the test results after the injury misconduct? I don't know that submitting to a test is misconduct, and the results of the test are simply the results. That's not his conduct. The misconduct, of course, was the consuming of the drugs, which I would suggest, for the benefit of the drug penalty, occurred prior to the injury. So I don't know. That one's a little tougher call. I have certainly suggested to opposing counsel that you betcha, positive drug screen is absolutely misconduct, and prove otherwise. But so, I don't know what to tell you on misconduct. It's hopefully you know it when you see it. If you see it, you can can them, and no more TTD. If you got questions about it, I would probably contact your insurance company before you do it, or if you work with the attorneys. If you're self-insured and you work with the attorney, call the attorney. I get questions all the time on that sort of thing. Just, hey, Matt, got a quick question for you. What do you think? And I'm not afraid to tell them my opinion, shooting from the hip, and I think it's helpful. Here's what you got to be careful of, though. This is what's called the retaliatory discharge. If you fire an employee for exercising their rights under the workers' compensation statutes, if you fire them in retaliation for exercising their rights under the workers' compensation statutes, you now have a potential tort claim against you. And when I say tort, what that means is a lawsuit in circuit court for damages. It's got a 5-year statute of limitations, and it is not covered under your comp policy. It's covered under your general liability policy, or your E&O policy, I guess. And it can be very expensive. Back wages, future wages, emotional distress, and all those things. And here's what's happening. It has traditionally been accepted that the standard for a retaliatory discharge in workers' compensation is the sole and exclusive reason, meaning you fired somebody for the sole and exclusive reason of them exercising their rights under the workers' compensation statutes. Now, how often did an employer say, Mr. Employee, look, you really shouldn't have gotten hurt on the job, and since you did, I'm firing you, okay? That didn't happen very often, so you could always come up with some reason you like to come up with reasons, and instead of I don't mean to pick on you, the random drug test. Well, they were late. I remember now, all of a sudden, a couple of weeks ago, and they've got those couple of black marks in their personnel file. So you could come up with other pretextual reasons. Well, what happened in 2010 is there were some changes, and the Missouri Supreme Court issued some decisions that basically said if an employee is fired for a violation, if an employee is fired in violation of Missouri public policy, the standard is not sole and exclusive clause, but rather contributing factor. So if that is applied to Missouri workers' compensation, and there's a case, Templemeyer versus M&M Welding or WW Welding, I can't remember which, that is now before the Supreme Court that is going to decide that very issue as to whether or not the contributing circumstance factor test applies to comp case, or is it still the exclusive remedy test. I'm telling you, I think it's going to be contributing factor. And so what that means, assuming I'm right on that, you were already going to fire somebody, and this happens. I've had these situations. I was planning on firing them next week. We were going to wait till the end of the pay period, and then lo and behold, they go and get hurt. So now I'm just going to fire them now. Well, what have you done? You've accelerated the timetable for firing them by even a day. Is that discharge on that day earlier than what you were planning on doing? Is the fact that they had a work comp claim, was that a contributing factor in your decision? Well, maybe. Certainly pretty risky. I've had some clients that weren't even that discreet. Get hurt. Well, I'm going to fire them. We convince them that maybe you don't want to fire them. Just wait until they're done treating and back to work and see how things work out before you make any such decisions. But it was that very situation where it was a bad employee. Their sales weren't what they were supposed to be. They'd been warned. They had every intention of letting this salesperson go. They just hadn't gotten around to it. Now they got hurt. You might have yourself an employee a little bit longer than you thought. Would be the safer thing to keep that employee on, because now if you decide, well, this is as good a time as any. I was planning on doing it anyhow, but now seems like a good time since you're out on TTD. We're going to go ahead and discharge you. I would suggest that there can be a strong case made that the workers' compensation claim was a contributing factor in your decision to terminate the person, subjecting you to potentially some significant damages. So we'll see what the court says, but I'm fairly confident, am competent as well, I think, that this Templemeyer case is going to come back and say that it is a contributing factor. So, and that's really, I'm sure, hits home with you all in the HR role. Be careful about that. So I talked about a couple of things there. What did I talk about? Answer within 30 days, post-injury misconduct, and retaliatory discharge. Yes, ma'am.
On the retaliatory discharge, we've got one right now.
A pending suit for, or you've got somebody you're wanting to fire?
No, we've been told he's getting away. On Friday,
Mm-hmm.
he got a third driving violation.
Okay.
His supervisor wrote him up. Saturday, he got injured. Monday, the paperwork made it to the office. Monday, he was relieved of his job.
I think you've got some defense. I think you've got a solid defense in that situation. Whenever you follow your own rules, I mean, you always hear lawyers, get the rules in writing, okay? And the reason we always say that is because then when you follow those rules, you're saying, look, I'm just blindly, I have the fact that this person has a comp claim isn't even coming into my analysis. I'm working through this framework that we already had in place, that we'd treat everybody the same way, 3 driving violations and you're out, and it's reasonable that if it happened on, did you say Saturday? Friday, but the paperwork Saturday and got to you. Yeah, I mean that's certainly a reasonable set of circumstances where you can say, nope, had nothing to do with the comp claim. He was going to get fired anyhow because of these 3 rule violations. Now, that's not to say that the jury. I mean, that could go all the way to a jury. Okay, it's not so lock solid that you can say, Judge, we want this thrown out because there's no reasonable jury could ever presume that there's, that this was retaliatory, how you've treated this guy in the past before, how you've treated other employees in the past, it might very well come into play, and a jury has the ability to make that decision. They are what's called the finder of fact, so they determine what is truth when it comes to these cases, and a jury could decide that in spite of the fact that you were following your own rules, that we think it was this other way. Now, I think in the facts that you've given me, limited to those facts, I think that's unlikely that a jury would do that, and I think you have a very defensible case. Now, when you say, now I've got some more information, and we told this guy he's a jerk for filing his claim, well, then that would certainly change the analysis, and I'm sure that there's nothing like that, but there's a crafty claimant's attorney can find something just to color it wrong and make it look like, and it's going to be a hassle, and so with the lower standard now, there's always that potential, even if you are right as rain and doing everything by the book. You've got that potential. And what did I say earlier? Can I file a suit? They can always file the suit. Will they win? Hopefully not, and I don't think so based on those facts. Senate Bill 1 is currently working its way through the General Assembly. Made it out of the Senate. It's now in the House. I was actually asked to testify before a House subcommittee on the bill. Basically, it's trying to fix our broken second injury fund. I'm sure you all have heard about the fund. It's out of money. What does that really mean to you? It's actually a big deal to you all. The fact that the fund is out of money means the fund is not making any settlements, which means more cases are getting tried, which means your legal fees and costs are going up, okay? Because you all are being held hostage by the fact that the fund isn't making any voluntary settlements. So the claimant's attorney is saying, well, I'm going to try this thing anyhow, so let's go. Let's try it. Let's bring everybody to the party, and let's just have a hearing. And so I'm just telling you that's in fact what is going on. The dockets for the judges is going way up. It's kind of leveled out some, but it really was on an upward tick, and I don't think it's gone down. I think it's just leveled off because of the fact that the fund's out of money. So what Senate Bill 1 is trying to do is raise the surcharge that you all pay to add some money to the fund. the quid pro quo that was suggested as some of the employers' groups saying, all right, that's fine. We know we got to save the fund. The fund is a good idea. It's better than us getting hit with perm totals. Let's keep the fund. We'll add some more money to it. But in exchange, let's stop paying out so many darn claims on perm total so that hopefully the fund will get healthy again and our surcharge will go back down. So we'll pay now so we don't have to pay later. Well, the problem is what's been proposed, while they have gotten rid of PPDs and some second job wage loss, I believe, out of the fund, they are keeping perm total, and they've added some language that I think the legislators feel like it's limiting perm total claims against the fund, but as a practical matter, it's simply not. There's 4 cases now when you can get a perm total against the fund, according to this bill. When your pre-existing injury is service-related, military, if it's a pre-existing work-related injury, if it is opposite body parts, you have a pre-existing elbow problem, now you have a shoulder over on this side, and if the pre-existing injury is significant and accelerates the most recent work-related injury. Well, what the employers groups are really trying to get rid of are these situations where somebody's got diabetes, they have a smoking habit, they're way overweight, they've got a depression diagnosis, and what the claimant's attorneys have been doing is using all of these things and combining those with the current injury and saying, well, they're permanently and totally disabled. All right? And that's not what the fund was originally set up for, and that's why it's run out of money with those kind of claims. Well, let me tell you, diabetes, smoking, obesity, hypertension, depression, they're all medically significant. Okay, I've never seen a record where the doctor doesn't put those in the record if they exist in part of the history of medical history. They put those things. Well, if the doctor's putting it in the record, by definition, it's medically significant because the doctor felt it was significant enough to mention it. Does it accelerate or cause additional problems to the healing process for the current injury? You betcha. Of course, all those things, at least to some extent, make it more difficult to heal. So, what have we done? We haven't, that opens the door right back up and puts everything back in. I testified to that fact and suggested it to the legislators. It's just, I don't know that it's, last night actually I was working on a draft and sending off to some folks that hopefully will ratchet that back. It's kind of, the political landscape is such that it's kind of fallen on deaf ears, and they've decided what they want to do, and they're getting pressure from different places in the mansion and so on and so forth that's causing these things to happen, and I don't think it's going to be a great bill for employers, and I think that's putting it lightly. In addition to the elevated surcharge to help rescue the fund, they're also adding this toxic tort stuff into the occupational disease, such that if somebody has mesothelioma, asbestosis, lead poisoning, some others, that the fund will pay, I don't know, some $400,000 or $600,000 to this person for that diagnosis if they are permanently totally disabled as a result of that diagnosis alone. And that's an additional surcharge on top of the already surcharge that's going up to help rescue the fund. And, of course, the proponents of that say, well, these mesothelioma is just a terrible diagnosis and really terrible, and so they deserve it. Well, I mean, a fellow who gets tore up in a scissor lift and is permanently disabled, what are you going to tell that family? Look, this is pretty bad, but it's not as bad as if you'd had mesothelioma. If somebody's permanently and totally disabled, whatever the reason, shot by a crazed gunman while they were just working on a power line, had that case, is that any less terrible than the mesothelioma? I don't think so. So it doesn't make any sense. I don't know why these were carved out, but I do know why. There's the political reasons and the claimant's bar. So what I'm saying is pay attention. That's Senate Bill 1. If you get a chance to take a look at it, maybe call your local rep, get educated on it, because it hasn't happened yet, but it's coming down the pike, and I think it could be a big deal as far as your all's bottom line. That's going to conclude workers' compensation. I spent a lot of time on that, I know. Now we got some time. How much time? Nobody's here, so we can just keep going forever. I'll do it. How will you guys? All right, I'm going to kind of zip through some of this unemployment stuff. I've kind of touched on it a little bit already, so we'll skirt through it. Before I do that, anybody have a work comp question of a general nature that I didn't address that maybe I can. If you've got a particular set of circumstances, you can certainly meet me afterwards and I'll try and help you out. But yes, ma'am. I'm sorry. I've completely neglected this side of the room, and I know that, and I apologize.
I'm just curious what your opinion is on how the Affordable Care Act is going to impact workers' compensation.
I don't think it's going to have any significant impact on workers' compensation. At the end of the day, your exposure for workers' compensation, the only way I suppose it would affect workers' compensation is if it drove down medical costs. And I'm not convinced it's going to. If it does, that will be the only effect that you will see. A disability is still a disability, and the body is still worth 400 weeks, and the doctors are rating these things at the same as they were before. The comp wages, they're not affected by the Affordable Care Act. It's based on the state average weekly wage. So, to the extent it affects your medical costs, that's the only impact I think you're going to see in the comp arena.
So those weekend injuries that show up on Monday morning that have always been sort of gray will still be more valuable to claimants for comp than if they weren't.
Well, they're going to be more valuable to comp, because if you hurt yourself hanging your lights, even if you have health care coverage, that's fine, but you're not going to get any disability settlement. The ticket is to get comp. Now, those are no more or less compensable in light of the Affordable Care Act than they were before. It's the same fact dispute that you've always had to try and get them kicked out of comp altogether. Yeah. Mm-hmm. Okay. So unemployment. A couple of basic requirements. Got to be a full-time employee. They have to have been fired. If they quit, they don't get comp or unemployment. And they don't get unemployment if they are discharged for misconduct connected with the work. All right? So misconduct, we saw that before in the post-injury misconduct, and that was an undefined term. That, of course, is a defined term in Chapter 288, which is the unemployment section or statute chapter. And in fact, virtually every unemployment case that sees the Court of Appeals, it's on a misconduct issue. So there's a very large body of work or cases out there that talk about misconduct. So here's the definition straight from the statute. An act of wanton or willful disregard of the employer's interests, a deliberate violation of the employer's rules, disregard of standards of behavior which the employer has the right to expect of his or her employee, negligence in such a degree or recurrence as to manifest culpability, wrongful intent, evil design, intentional and substantial disregard, blah, blah, blah. It's not, oops, I got into a car accident, okay, by itself. Oops, I got into a car accident 3 times is probably not misconduct, and they would probably be entitled to unemployment. Okay, putting aside the workers' comp issue for a moment. 3 separate car accidents over a reasonable period of time. If they're 3 in a day, okay, now wait a second. There's something going on there. They're smashing up your cars. Okay, but 3 oopsies over a reasonable period of time, that's not going to be misconduct, and they are going to be entitled to unemployment, I would suggest. It's not to say I wouldn't fight it if you decide financially it makes sense. And that's the problem. Oftentimes, it doesn't financially make sense. I've taken a few unemployment cases to hearings. I've taken a couple to the Court of Appeals. I went to the Supreme Court one time on an unemployment case when I was with the division of, I see you back here. I see you in a second. When I was with the Department of Labor. But, it just, if you've already fired a bunch of people, your rate's not going to go up a whole lot, so your unemployment, costs each quarter are not going to go up substantially, so people don't fight it as often. But, it really has to be a drunk at work, just flat didn't show up, insubordination. Those are the kinds of things where they intentionally did something, they made a choice, and it was the choice to be a bad employee. Yes, ma'am? Well, I'm not sure under what circumstances that happened. Generally speaking, it's a full-time employee.
What was the question?
The question was, we've paid unemployment to part-time employees. generally speaking, it's a full-time employee, so I'm not sure what the special circumstances were. Yes, ma'am?
Well, we have a lot of seasonal employees.
And, during that season when they are full-time,
And then we get all this paperwork from the Department of Employment Security because they filed when the season's over.
right, got laid off.
Right, and we laid them off, but they're really not full-time employees. I mean, they might have worked full-time hours, but they really were classified as seasonal only through a very short period of time. So I think that's kind of I'm curious about that too because I think
Yeah, it may be that they were treated as full-time because of their hours, albeit for a specific range of time. And so they made enough wages in their base. And I got to say, I didn't get involved in the administrative stuff, so how they calculate the base rate and all those things, and they look at certain periods back, it's sort of obtuse, maybe purposefully, so we don't know what's going on. But it's, so if they made a certain amount of wages during a certain base period to qualify, and if they were full-time at least during that time and then laid off, in those situations, I think, they're maybe getting unemployment. Not misconduct. Excusable absence. My alarm clock didn't go off. An actual case. Acts of negligence. Okay, he got into the car accidents accidentally. Absence due to a medical reason. That was a case that I argued before the Supreme Court. I can't specifically remember the facts or circumstances. It was a terrible case to take to the Supreme Court because we were most certainly going to lose because it was a very sympathetic case. Miss Amy DeFata Wheaton had cervical cancer and couldn't come to work, stopped showing up, and she was denied unemployment. And it ended up getting up through the comp system. I represented, as the Department of Labor, I represented the commission. The commission made a decision, and Ms. DeFata Wheaton obviously disagreed with the commission, and so I was there to defend the commission's decision. I didn't represent either of the parties. But it was Supreme Court. I lost. I'm over in front of the Supreme Court. The unemployment was granted to that woman for her inability to show up to work because of the cervical cancer. Can't say that I disagree with that. Yes, ma'am. I'm sorry? That's right. That's right. Well, and that obviously came into play in that for whatever reason. I think it came down to the absences. It wasn't that she was due to some treatment that caused her to temporarily be able to come in, but she was not permanently disabled due to the cervical cancer. She was ready, willing, and able to work during the periods that she reported. So, now, as it turns out, interestingly, her ex-husband, who I think had an axe to grind, faxed me something right before I argued the Court of Appeals that suggested she might have been lying at some point during the proceedings. But there was nothing I could do with it because at the Court of Appeals you don't introduce new evidence. You either defend or argue with the decision, the legal decision that the lower courts made, but it's not an opportunity to introduce more evidence. But as it turns out, I think there were some shenanigans going on. I just can't remember specifically what they were. Constructive discharge. Even if a person quits, it can still be treated as a discharge under certain circumstances. Such circumstances are a change in pay. All right, if you reduce their pay and they say, I quit, that can be considered a constructive discharge because there was a substantial change in the working environment. Change them from salary. Yeah, that next one. Change them from salary to hourly. Even if under the hourly framework they have the potential to make more money, that's still, and I know that because I argued that at the Court of Appeals. I lost that one too. I did win some cases. This woman, I had the math. I said, look, she's making more now. And she was changed from a maintenance supervisor to just a maintenance worker with making more money because now she's being hourly. Basically, she was slacking in her salary position, but she was the aunt of the person who owned the company. So they said, well, you're not going to be a supervisor anymore. You're going to be just a maintenance person and hourly, so start writing down your hours because we think you're maybe exploiting or taking advantage of the aunt-nephew relationship. And she quit, and she got unemployment in spite of my best efforts to the contrary. Change in duties, that was one of the things that the courts talked about in that particular case, changing her from a supervisor to a maintenance employee, even though her duties didn't really change. On paper it sounded like they did. That was enough. Intolerable work environment. I'm sure you all have heard if there's sexual harassment and things like that going on, inappropriate things of that nature, somebody quits, that would be treated as a constructive discharge. Constructive resignation. If they can't come to work because they've got a medical problem, unassociated with work, not a comp thing, just whatever, the employer says, well, okay, that's fine. We'll keep your job open for you if you will just fill out this leave of absence form, and you'll get 24 weeks of leave of absence. And you don't fill out that paperwork, that can be treated as a resignation. And comp, not apply. Unemployment, not apply. So that's one example of constructive resignation. I'm sure there are others. That's the one that comes to mind. Some practical things that I've seen come up in the unemployment scenario that probably most people don't realize. Giving the employee a pass can be a problem sometimes. I think probably from a business standpoint, it's probably a good thing. It costs money to hire new employees. You don't want to be firing everybody all the time. But just keep in mind, if somebody does something that is significant enough such that you're really aggravated at them, you might going to fire them, but you're going to give them one more chance, you give them a pass, and then down the road they commit some other bad act that say, all right, I'm going to fire them, you might not be able to use that. Well, look, not only did they just now screw up, which may not be misconduct by itself, but when you look at this current situation plus what they did 2 months ago, that's why we're firing them. They're not going to buy that. All right. Once you give them a pass, it's kind of like the slate is clean. They are absolved of their sins when you give these passes. So your ability to consider prior bad acts sometimes can be difficult. Now, if you are using the prior bad acts to show a pattern or an evil motive, evil intent, things like that, it will come into play. But if they're, certainly if they're two different types of bad acts, one of them you said, all right, I'm going to waive it. We're going to work on this. I'm going to make you a better employee, and then they do something else dumb. You might not be able to go back and say, well, look, there's two things I did here, so they combine for an evil motive. That's not going to fly. So keep that in mind. I mean, I'm all for grace, and especially if they're a good employee, and you want to try and keep them on and turn them into a better employee. But don't be sitting there thinking you're keeping a ledger of all the things they're doing, and so I'm going to be free of any unemployment concerns. Questions about that real quick? I'm going to just touch on some when you can fire and when you can't people, and then that'll probably about wrap it up. Questions about those things that I just described and discussed? Yes, ma'am.
I have a question about the no-call, no-show. We do a lot of policy manuals for our business, and so we have a lot of employers that do that 3-day no-call, no-show.
Mm-hmm.
And, there's a couple of schools of thought that we hear often are, should employers try and reach out to that employee just to make sure they're not lying in the ditch somewhere or, something awful, and that would work in their favor just to demonstrate that they did do that. And then on the other school is, I have some employers that they don't want to do the, 3-day no-call, no-show. They just want to do one shift. Do you have any recommendations on that?
I think the 3-day no-call, no-show is probably you're going to have better success with the 3-day no-call, no-show. One, because it is just such a common in the courts that they are willing to accept that is misconduct, and so anytime you can find a basis that's already been tested, tried, and true, I think you're going to have better success and better predictability. Anyhow.
How about the employers making it that they've at least attempted to call that employee?
I don't think that's going to come into the, it's the employee's responsibility. If that's your policy that, look, if you're not going to make it in, you need to call us and let us know. That there, at no time is there, does the employer have a duty to babysit and track down their employees. So I don't think that comes into play at all. Yes?
Do you have to specify in your policies the 3-day no call, no show, or just if you say policy, it's your duty to, because we have it a lot less, you have to tell us if there's a delay.
To the extent you can specify, it's always better, okay? Because what is misconduct? Okay, there's no list of these things are misconduct, okay? And so it's when you can establish that they're breaking the rules that the employer has the right to expect of the employee. That's one of the things in the definition. So if you say, if you don't show for 3 days, then you're fired. That is a rule then that you have the right to expect. If it is, you need to not be absent unless absolutely necessary or something like that, well, what is absolutely necessary? How many days have you? I mean, it just leaves open the chance that you could lose. Okay, the more specific you are. Now, that doesn't mean you can say, look, if you're 30 seconds late, you're fired, and you violated it's specific, so that's evil motive. That's not going to fly. So if it's reasonable, your policy, and predictable and identifiable, all those things, then the employee knows that they screwed up. There's no gray area. Gray areas are bad. They're great for me. Gray areas make lawyers money, but they don't make you any money. Okay. So real quickly, Missouri is an employment at-will state. Used to be. It is, but not as much as it used to be. And that's kind of the growing trend around the nation. It's not just Missouri. An employee at will may not be terminated for refusing to violate the law or any well-established and clear mandate of public policy as expressed in the Constitution, statutes, so on and so forth, or for reporting wrongdoing or violations of law to superiors or public authorities. There was a set of three cases that came out in 2010 that really dealt with this employment at will situation and exceptions to employment at will, and this was the holding of one of the cases that an employee cannot be fired if they refuse to break the law. I don't think that's a bad policy. The employee, another one, the labor standards had called up and asked a secretary about some information because they were trying to figure out if there was some failures on the employer's part with regard to minimum wage or some reporting thing, and the secretary gave the information that was requested of her, and she was terminated, and the court said, no, you can't do that. The employees should be able to respond to inquiries by government authorities. So those are some examples that came out just in 2010 and changed the law a little bit. If you were to fire somebody for some reason that is against public policy, and it's against public policy if it violates a statute almost universally. So if the employee is following the statute and you're firing the employee for following the statute, or if the employee refuses to violate a statute and you fire the employee for refusing to violate that statute, those are always going to get you. You can't do that. That'd be a wrongful discharge, and you're going to get hit with back pay, forward pay, emotional damages, so on and so forth. This also applies to contract employees. I think that was a revelation in those series of 2010 cases. So it's not just your actual employees, but contract employees as well. It's kind of a restatement of what we just talked about. It was the third case. This is the holding from it, and basically says the same thing, that violation of public policy is not a good reason to fire somebody. And not every statute or regulation gives a rise to at-will wrongful termination. A vague or general statute, which one might argue all statutes are somewhat vague. But so the pertinent inquiry is whether the authority clearly prohibits the conduct at issue in action. This is a lot of stuff that gets us labor attorneys excited around coffee. Probably pretty dry for you. It is for me. Basically, the takeaway here is don't fire any of your employees because they refuse to violate the law, or if they were committing some act that they were compelled to do by a law, or responding to a governmental agency or authority. that is not a permissible reason to fire the employee. Some examples: Missouri Human Rights Act, whistleblowing, Labor Department calling up, and I've got this comp claim down here with a question mark because that's what I told you is right now in front of the Supreme Court under that Templemeyer case, where they're going to decide whether or not firing somebody in retaliation for the workers' compensation claim uses the same threshold as contributing factor versus the clear and sole factor, sole and exclusive factor that it used to be. Any questions about any of that? Okay, I believe that is... Any questions about anything? Work-related, comp-related. Yes, ma'am. No. Municipals are kind of a funny deal. The municipal ordinances are not always laws. Sometimes they are, sometimes they aren't. For instance, going to municipal court for violation of a municipal ordinance is not the same as breaking a statute, okay, and you're not guilty of a crime. So municipal ones are a little bit funny, all right? But putting that aside, definitely state rules and regulations apply, same as federal. Okay, and that's my contact information. You've got it on the last page of the notes. This is a genuine invitation. If anybody has some questions that we weren't able to cover today and you want to shoot me an email or you want to pick up the phone and call me, feel free to do that. I actually enjoy talking about this stuff, in case you didn't notice. So, if you've got a question, I'd be more than happy to try and answer it for you. It's not a situation where you have to be somebody that I already represent. I get a little sketchy about you've already got an attorney that is telling you one thing and you're calling me up to say, hey, is that right? I'm not a big fan of commenting on other attorneys' work just because I don't always have all the facts, and it's not because you would purposely omit them, but just what you might think is an important fact. I think something else is an important fact. So, I've got to work with other attorneys. But having said that, still, I'd be willing to talk about the situation with you. But if you have a general question, that feel free. Give me a call, shoot me an email, let me know. I'd be more than happy to try and help you. Okay? Thank you very much for your time. I appreciate the audience.